Fox 35 News Plus, streaming on Fox Local.
Welcome back into Fox 35 News Plus. I'm Garrett Weimer, and thanks for joining us on this Wednesday morning, live on Fox Local and on YouTube. A federal judge temporarily blocked parts of Florida's new social media law, citing concerns over the First Amendment. So this is the law that bans children 13 and younger from having social media accounts, and also requires parental consent for 14 and 15-year-olds. It also mandates age verification for users who are accessing harmful content. Now, we should note that the Attorney General for the state of Florida, James Othmeyer, has quickly appealed this decision, so things are not settled yet. But that parts of that law temporarily on hold right now after that federal judge stepped in. Joining us live now via Zoom to talk about this case and where things go from here is Matt Shears, who's the president and CEO of the CCIA. That is the Computer and Communications Industry Association, one of the groups that actually challenged this law in court. And Matt, we really appreciate you joining us this morning here on Fox 35 News Plus.
Thanks for having me.
Hey, Matt, first I want to get your reaction to this injunction, this temporary block of this law.
Right. So yesterday's ruling vindicates what we've been saying all along, that Florida's law violates the First Amendment by blocking and restricting minors, and likely adults as well, from using certain lawful websites. We argued that the state cannot lawfully ban young people from going online, and it can't say to teens, as a condition of going online, you have to disclose who you are and where you live and how old you are and who your parents are. Our argument is that the First Amendment doesn't allow the state of Florida to gatekeep speech like that, and the court agreed with us yesterday.
The Attorney General, as we noted, quick to appeal, and in the statement saying, in essence, that these social media companies don't have a constitutional right to get kids addicted to their websites, their products. How do you respond to that?
Look, yeah, there are legitimate questions about when and where and for how long young people should be going online, and every family needs to make those decisions. But those decisions are best made around the dinner table, not Governor DeSantis's desk. And that's what happened here. Now, what we need to do is empower parents to make decisions with the tools that they have available to decide how young people in their family should be using these services, but not have those decisions made by politicians. They're better made by parents. And so the plaintiffs here did not challenge a provision that compels companies to give effect to a parent's request that a website terminate a young person's account. So that provision stays in effect today because it's one that empowers parents to make decisions on behalf of their young people, not politicians.
Why was it important to you as president and CEO of the CCIA that your organization get involved and challenge this?
So young people themselves have First Amendment rights, and the court makes very clear in its opinion yesterday that they're not pre-citizens, that they're citizens themselves, and they should be empowered to interact with and express and voice their opinions. The services that they're using also have a First Amendment right to make those products available to young people. And our point is that policymakers can't short circuit their citizens' First Amendment rights by making these hyperbolic claims. Time after time, regulators have encountered new media, whether it's comic books or rock and roll or cable television or video games, with overheated claims. And what the court said, as it said in the past, is that state regulation of expressive products like this has to be narrowly tailored. And kicking a generation of young people offline is not narrowly tailored.
This is a conversation that has been going on and growing as these social media platforms have become more and more prevalent and pervasive, as these smartphone devices have been getting in so many more people's hands. It's everywhere now. So my question is, is there some regulation of minors being able to access this that you and your organization are okay with, or where do you think that line needs to be?
Well, so as we saw in yesterday's opinion, only parts of this law were challenged. The parts that empower parents to make decisions about what's appropriate for their young people. And if they ask a website to terminate their child's account, that website should give effect to that, is the kind of parental empowerment that we want to see. But every family is different and every service is different. Different services have different offerings, and families should choose based on what's available in the marketplace, what's appropriate for their young people. And so we have seen laws that try to empower families through education and awareness campaigns about what tools are available, but banning young people from the internet or gatekeeping their access to speech unless they disclose all this personally identifiable information is not the right path forward.
As this case continues to move forward now with this appeal, are you confident in your case, your argument here?
Yeah, we're confident that when this gets up to the federal appeals court, that the arguments that we have made that succeeded yesterday will succeed again. That's consistent with the decisions we've been seeing on similar laws like this across the nation.
Why is this such a concern in your view?
So, as I said, time and time again, when policymakers have encountered new media, there is often an overreaction and overheated rhetoric that leads us to make decisions that, in hindsight, seem frankly ridiculous. We went through this with video games 2 decades ago, and what we've seen is that tools that empower parents with information that allow families to make their own decisions about what's important are far more appropriate and far more effective than decisions handed down by regulators in the Capitol deciding by fiat that these people can't access this speech. That's just not how the First Amendment works. And the United States has a long tradition of defending the First Amendment rights of businesses, of young people to communicate and express themselves. And yesterday's decision was very clear that this is one of the most powerful means that Americans have to express their views, and to kick a generation offline because of these overheated concerns is not the right thing to do.
All right, it's going to be interesting to see where things go from here. Something we will, of course, continue to follow as it moves through the court system. Matt Shears, co-plaintiff here, and the president and CEO of the Computer and Communications Industry Association. Really appreciate your time this morning, and thanks for joining us here on Fox 35 News Plus.
Great, thanks for having me.
We're going to take a break, and we'll be right back.